Welcome to True Crime Boss. I'm Jarrett Ferrantino. Significant developments in Idaho in the prosecution of Bryan Kohberger for the murder of Zaina, Kaylee, Maddie, and Ethan. Bryan Kohberger, through his attorneys, has lodged a series of challenges against the grand jury process and the indictment that prosecutors handed down against him. Kohberger's attorneys claim there was a lack of sufficient evidence to move forward. They claim prosecutors committed prosecutorial misconduct, a mortal sin in our business, folks. They also claim that jurors were biased by certain instructions and certain information that was presented to them. They also claim that the prosecution withheld certain exculpatory evidence that would have been beneficial to Bryan Kohberger. The judge has ruled today, and we're going to break down the developments that have come out as a result of that ruling. In addition to those challenges, Bryan Kohberger's defense team has lodged a series of procedural challenges to the grand jury process that prosecutors used. Let's start with the procedural challenges first. The procedural challenges that the defense made against the grand jury process in Idaho were things like the forms that were used and completed by prospective jurors were inaccurate or incomplete or weren't signed in the proper place, or certain questions weren't answered. And they claim that these deficiencies in the jury selection process mar the entire process, and the indictment against Bryan Kohberger should be thrown out. Folks, if you've ever been selected for jury duty or have ever been part of that process at all, you do fill out forms. You're asked questions that aren't entirely clear to attorneys. I can imagine as a prospective juror, you're nervous and you're filling out those forms. You may miss an answer. You may sign on the wrong place. That's just how it is. And folks, that is not the kind of challenge that is likely to be successful or result in the throwing out of the indictment or the dismissal of the charges against Bryan Kohberger. This was not a surprise that remember folks, the judge in this case is Judge John Judge. So if I say judge twice, that's who we're talking about. It's a mouthful, that's for sure. But Judge dismissed the procedural challenges against the grand jury indictment in this case, and that was no surprise. And you may ask yourself, why would defense attorneys even make that claim? Or why would they try to do that? Folks, they're defending Bryan Kohberger's life. And Bryan Kohberger's defense attorneys are working really hard to challenge the prosecution. And to effectively challenge the prosecution, you got to challenge them at every step. And it begins with that grand jury process. And that's exactly what they're doing. They are picking apart with surgical precision every little aspect of that process, looking for some kind of a mistake that can prove fatal to the indictment and result in the dismissal of the charges. They haven't found it yet, and Judge ruled in favor of the prosecution for the procedural challenges. Now we get into the what I'll call more spicy challenges to the grand jury process here, folks. And here's what they are. First, they claim the prosecution withheld exculpatory evidence that would have benefited Bryan Kohberger. What does it mean? What does the word exculpatory evidence mean? Essentially, exculpatory evidence is anything that would show that Bryan Kohberger is actually innocent of this crime. So to call something exculpatory, them are fighting words, folks. That's a pretty large claim. And you may ask, what exculpatory evidence are the defense attorneys claiming was not shown to the grand jury? We don't know, folks, because grand jury proceedings are held in secret. They're veiled in secrecy. In fact, the very argument about this exculpatory evidence or alleged exculpatory evidence, folks, I'm not suggesting that any evidence exculpatory in nature exists. Even that hearing occurs in secret. So we don't necessarily know what that evidence the defense is claiming the prosecution didn't show the grand jury. All we know is this. It wasn't enough for Judge to dismiss the grand jury indictment if it existed at all. So that challenge didn't work. The second challenge was that failure to show exculpatory evidence was actually prosecutorial misconduct, misbehavior on the part of the prosecution. And the judge really wasn't having that either. Part of the exculpatory evidence claim is also wrapped in a charge of prosecutorial misconduct. The defense is making a claim that the prosecutors misbehaved or did something incorrect on purpose to harm Bryan Kohberger or this prosecution or the case. There's been no finding that the prosecutors have engaged in misconduct of any kind. Whatever that challenge was, and I'm reading the tea leaves here a little bit, folks, it looks like it was wrapped in some claim involving that exculpatory evidence. Again, the judge just wasn't buying any part of that, and he has not found that any of those claims would justify the dismissal of the grand jury indictment against Bryan Kohberger. The other major challenge here was largely a legal challenge. And you hear things in the law, and you may say to yourself, I'm not sure there's a distinction or what the difference is between these two concepts. You may hear the words probable cause over here, and then you'll hear the words beyond a reasonable doubt. Okay? Folks, those standards are two of the most significant standards in criminal prosecution. The standard for an indictment to come down from a grand jury is probable cause. Let's look at it this way. Look at the word. There's been enough evidence presented to a grand jury that you're probably the one that did it. And there's enough evidence to send on to a jury at the courthouse to assess your guilt or innocence. And in a grand jury setting, there's enough evidence to indict you because you're probably the person that did it. That's the easiest way to describe the probable cause standard. Over here, we have the beyond a reasonable doubt standard. And folks, if you're familiar with that concept, that is the standard for trial juries. Trial juries and grand jury, investigative grand juries, are very different. Investigative grand juries are trying to determine if you probably did it. Trial juries are saying you did it beyond a reasonable doubt. A much higher standard, a much larger burden for prosecutors and defense attorneys to hold prosecutors to account to prove. So what the defense attorneys in the Kohberger case were saying was that the Constitution and the law should protect defendants like Bryan Kohberger, so much so that the standard for even bringing down an indictment should be beyond a reasonable doubt. Folks, that is really a challenge to the Constitution of Idaho and to the Constitution of the United States of America. The judge was certainly listening to these arguments. The judge called them creative. They were certainly thought-provoking, but he wasn't buying it. He really doesn't have the authority to impose a higher burden on the grand jury process. And he said as much in the portion of this hearing, because this hearing was a legal argument and not involving secretive information that was presented to the grand jury, this portion of the argument was public, and Judge sat back. He was actively listening. He was engaged. He's been respectful to everyone through this whole process. But it was clear, if you followed his logic and questioning during those proceedings, he was saying to the attorneys, these are the higher court's directions that they've been providing to lower courts. This is the law. This is the Constitution. It was pretty clear where he was leaning with regard to that particular challenge. So no surprise there. Essentially, folks, the judge is saying to the defense attorneys, you have not proven to me that the beyond a reasonable doubt standard should be applied to a grand jury indictment. And really, folks, applying common sense to the law, sometimes the law doesn't make common sense. It really serves to reason that an investigative grand jury need not prove beyond a reasonable doubt that a person is guilty. They don't have that person sitting there. They don't have all the information. They're really just considering if there's enough to hold this particular person on to the next level after indictment. And that beyond a reasonable doubt standard is the one we see every day on television and in courtrooms every day. That's the one that's going to hold your feet to the fire. And ultimately, folks, the evidence that's been presented in this case and that will be presented in this case before a jury, while Bryan Kohberger's life hangs in the balance, is going to be tested to that beyond a reasonable doubt standard. So if Bryan Kohberger did not hold the prosecution to that standard when it came to the grand jury, he and his defense team are going to have that opportunity to do so in the upcoming trial. And that is a constitutional guarantee. So the fact that the defense has lost these two motions to dismiss are certainly no surprise. I don't think they're a very big surprise to the defense. They're certainly part of this process in providing a lawful and fair defense to Mr. Kohberger. And you may sit there and say, Bryan Kohberger, in my mind, is guilty, and I don't think he deserves a fair defense. Fair enough, folks. But in the United States of America, remember one thing. You are presumed innocent until proven guilty. And Bryan Kohberger is entitled to a defense, and a fair, compelling, strong defense. And he's getting that. It's clear. These attorneys aren't messing around. They are going to hold this prosecution's feet to the fire. This prosecution also is not fooling around. This is a death penalty case. They know they're going to be challenged at every pass. The scientific evidence, the circumstantial evidence, the direct evidence, the eyewitness evidence, everything that's going to be presented is going to be held to that beyond a reasonable doubt standard. So the developments today in Idaho is the trial will proceed. We don't know when, folks. If I'm making a prediction, maybe toward the end of 2024. I know people aren't going to be happy to hear that, but this kind of justice takes time. And it's going to take time to get through the pretrial motions that are forthcoming, some of the DNA matters that are currently pending. I've been through big trials like this before, folks. It takes a long time to get there. The road to justice isn't pretty, and it's often long, but we will get there. Stay tuned. We're going to continue to cover the motions and the decisions as they come down. Thank you.